You're listening to Cover Your Assets, a podcast that discusses the timely and significant legal issues faced by employers. Kathleen Jennings is an attorney who has over 30 years of experience in advising employers as to their legal responsibilities and has written extensively about employment law in her popular Cover Your Assets blog. If your business has employees, you cannot afford not to have your assets covered.
All right, welcome to the second episode of Cover Your Assets, the companion podcast to the Cover Your Assets blog. And of course, my name is Thom Jennings, and I am here via Zoom with yours and my favorite attorney when it comes to all things employment. Ladies and gentlemen, my sister, Kathleen Jennings. How are you, sis?
Doing great, Tom. Thanks for that wonderful introduction.
So this week's topic is one that is very pertinent and certainly something that employers really need to consider. And your blog is actually called an employment blog. But unfortunately, sometimes when it comes to employment, that employment needs to end. And the termination of an employee is, I would say, probably one of the most difficult things that an employer has to face. There may be situations where it's clear that an employee has to be terminated because of some egregious action. But in many cases, it can be a little bit more nuanced. So today we're going to talk about some of the things that an employer should do. And Kathleen, what did you title this topic?
The title of the topic is Handling Employee Terminations with Dignity. The reason that I decided to call it that is because we're talking about human beings and we want to treat them with compassion if we can. As you pointed out, there are folks who deserve to be terminated, have done something so egregious that the decision to terminate them is obvious and necessary. But for the most part, when people are terminated, there's been a process, or hopefully there's been a process leading up to that point. The termination is going to have an impact, obviously, on their livelihood, on their family. And so you want to handle it in the best way possible so that you can cover your assets by making sure that this employee does not become angry or humiliated, which will cause them to potentially contact an attorney, the EEOC, the Department of Labor, or any other outside agency that is then going to try to get all up in your assets.
Yeah, and I think the other thing that's important as well is if you think about it, in today's climate especially, where it's getting more difficult to find employees, much less good employees, that you really can't afford the PR nightmare of people having a bad experience with a particular employer. Because just happened to me yesterday, as a matter of fact, I had a friend reach out to me through Facebook and say, I know you used to work at this place. What are your impressions of it? So if I had had a negative experience with them, I certainly would have told them that they probably don't want to work there.
And that's a great point, Tom, because with social media, it's very easy for applicants or current employees to reach out to former employees and get that kind of information. Back when I first started practicing law, we didn't have to worry about that. You actually had to call somebody up on the phone or meet them for coffee or something like that. Now, with Facebook and other social media platforms, it's pretty easy to reach out and get unfiltered opinions of someone's former employer. And if that employee is angry or upset or feels like they were mistreated, they're going to communicate that.
And well, before we get into the process in terms of dealing with these more nuanced, termination situations, can you maybe go through a typical list of things where it is cut and dried, and then the difference between handling a situation, let's say employee stealing versus a performance issue?
Sure. First, we'll back up and just state in states like Georgia. Georgia is one of the few states left where we have what's called employment at will, which means you can terminate an employee at any time for any reason or no reason at all. That's under state law. There are other states, such as New York, that have exceptions to the at-will employment law. You cannot terminate people in retaliation for filing a workers' comp claim or something like that. However, even when the state allows you to terminate someone for any reason or no reason, you have to be mindful of federal law. And if your workplace is covered by Title VII, which means you have 15 or more employees, then if you fire someone for a discriminatory reason, you can get hit with an EEOC charge and a lawsuit potentially. Also, if you terminate someone for reporting a safety issue, OSHA can come after you because that's illegal. Or if you fire somebody for reporting a wage and hour issue, the Department of Labor can come after you for that. So while it may seem like it's a great thing that you can terminate an at-will employee, you have to be mindful that there are limitations on that. In addition, you want to be mindful of how the termination comes about, because that is going to dictate how the employee takes the next steps after the termination. So what you want to do in a case of perhaps a performance issue, you want to have the paper trail. Of course, the attorney is going to ask for the paper trail. And if a client calls me up and says, I need to terminate Bubba because this is just a poor performer, my first question is going to be, well, is Bubba going to see that coming? Does Bubba know that termination is imminent? And he would know termination is imminent if he's been progressively disciplined, he's been counseled, and perhaps the last step leading up to that, he's been told any more further infractions or further problems will result in your termination. So he should know it's coming, unless he's in denial, and that happens. There are some infractions or some violations that are so egregious, such as an employee assaulting another employee in the workplace, sexual harassment, or theft of company property, that will result in immediate termination, and they should see it coming because they did something really bad, but that's not something that necessarily requires progressive discipline.
So in a case that you mentioned, we'll say, I think sexual harassment is one we can maybe dig a little bit deeper into. What, is the employer obligated on some level to present evidence of the sexual harassment? I mean, in a case like an assault, I would assume that that's pretty cut and dried. You've got maybe video or injuries or witnesses and things like that. In a he said, she said situation, that must be very delicate for you to deal with, because if the employer you could say, oh, well, the employer's just trying to get rid of somebody. Maybe they didn't see it coming, because this is really kind of the theme here. We're saying, hey, your employee should know it's happening. But if there's maybe an off-color statement made or something that's done in the case of a sexual harassment, but it's only between two people and there's no other evidence, could that be a real problem as well?
Well, Tom, I think that would actually be a great topic for a future podcast, because that's going to come down to how you investigate the complaint of sexual harassment, what information you gain from that investigation, and what conclusions you reach as a result of the investigation. So I think that that's something that we could cover at a later date. But obviously, there needs to be an investigation. And if the conclusion of the investigation is that the person who is accused of sexual harassment needs to be terminated, then that needs to be communicated to the person. I think the other important thing to remember when you terminate someone is tell them the truth. Tell them the truth about why they're being terminated. Because if you give them a reason that's not the truth, or a reason that's false, that also can lay the groundwork for a potential discrimination claim. Because if that's not the real reason, then the employee or their attorney will say, well, this wasn't the real reason for termination. The real reason must have been discrimination or retaliation or something unlawful. So be honest.
So, in a I know this situation has happened to friends and we had places that I worked at where everybody talks about the paper trail. You want to make sure that you cover yourself. You have a certain amount of verbal warnings and written warnings and all that kind of stuff. But when that process begins, I think sometimes that an employee can feel like they're being targeted and that the employer is beginning the process of trying to terminate them. Is there advice that you would give to an employer in those early stages where they are beginning to address performance issues that maybe doesn't turn that whole thing into something that lacks dignity?
My advice would be, first of all, to be consistent among all of your employees. If your process is initially we have verbal counseling, which will be documented, and then have specific steps that you go through that lead up to termination. Don't target just one employee that you've gotten tired of. Make sure you use this process for all employees that have similar performance issues.
And is there any benefit or problem with I know I've worked for employers that have that email that is sent to the entire workforce that is really meant to address two or three people. For instance, if you have a couple employees that are consistently late and then the employer sends out an email that says, "Hey, if you keep being late, you're going to be subject to progressive discipline." Does that work as far as documentation, or is that just something that maybe you would say is probably not a great idea?
I personally don't find those types of emails productive from both ends, either from the employer end or from an employee end. The better approach would be to address the issues individually with the people that have the performance issues. Or in this case, if someone's late constantly, you need to meet with that employee, you need to document the lateness, and you need to let the employee know further incidents of being late within X period, which should be consistent with the company's policy, are going to result in further discipline up to and including discharge. And when you do this documentation, my other very strong advice is make sure the employee signs it. Because what we find out is employees will tell you, if I didn't sign it, it didn't happen.
And that's, I mean, to me, I think that's a very common thing. I know that one employer that I work for, there was an employee that was written up and they just said, "Well, I'm not going to sign it." And then I think we had a process where I believe I was brought in to sign something to state that they were given this particular document just to prove that the exchange even happened. Is that something that you kind of need to do? And I think there's a gray area there too, because if I'm an employee who's not involved in the discipline process and you kind of drag me in, maybe this coworker's my friend, and now I have to sign this document about their performance. I mean, that actually, I remember it being a very uncomfortable situation for me, but again, I don't know how you would handle that unless maybe you have the HR person and the supervisor, they're both signing that they had presented it.
I agree with you, Tom. That's not ideal to drag in a coworker who's not involved in the situation. The better approach would be to have, in any of these types of meetings, two people anyway, perhaps someone from HR, perhaps the supervisor. And if the employee refuses to sign, then they can document employee refused to sign and they sign their names to it also. But that way you have two witnesses to that incident. And you should generally do that with any of these kinds of personnel meetings, especially that discuss performance, potential discipline, and termination.
And does email suffice in terms of a warning? I mean, a lot of people can receive emails and say that they never receive them. I mean, is that an issue with employers?
It could be. Again, it gets back to, yeah, you have the documentation, but if you don't have some kind of verification in the form of an employee signature that they received that email, some employees are going to say, like you said, "I never saw it. I was never given this warning," or something to that effect. Again, if they don't sign it, it didn't happen. And so that's why it's very important to make sure that you get the employee to sign and acknowledge the steps of the written discipline process.
All right, and let's close up with a case study, and this is a personal one. This is a situation that happened to me a few years back, and I was working for an employer, and it was the Friday before Christmas, and I was called into the office. I was actually in a Santa Claus suit. I was working for my employer, and I was overseeing a daycare as part of my general duties, and I was playing Santa. And the Friday
I
before,
find that hard to believe, Tom. I mean, I guess people can't see you in the
right?
podcast, but if they see a picture of you, I think they would understand
Yes,
why you would have been in a Santa suit.
I am typecast. I have a white beard and a big personality, and I also have a lot of elves working for me. So those are the three things. But no, I don't have any elves working for me. But
Not yet.
if I did, you would be my attorney to represent me in case I had some issues with the elves. But
And I appreciate that.
so the situation was, it was a Friday before Christmas. And I say that because, again, we talk about, terminating an employee with dignity. And I think that terminating an employee near the holidays is a consideration. I think employers should at least look at that. And, or, if they've just experienced a tragedy like a death in a family or something like that. But anyhow, I was called in, I was given this written documentation. I don't need to go through the particulars of it. But as we were discussing this and preparing for this particular episode, I think the conclusion we draw is that the first thing you asked me was, did you see this coming? And in all honesty, I didn't see this coming from a mile away. And even the list of grievances were all very minuscule, and none of which had been addressed with me before, none. And then I was asked to sign a document. I didn't sign it, and he was literally the only person in the room. It was just me and him. And eventually this wound up leading to legal action on my end. And I can't really say...
Well, tell us, Tom, how did you feel about the way that was handled? How did it make you feel?
The same way I feel now. Obviously, I'd say you could probably still hear my voice. I mean, who fires somebody the Friday before Christmas, first and foremost? But
in a Santa suit.
Like,
who fires Santa?
I know, the visual
Friday
is like,
before Christmas.
My goodness,
yeah,
Santa. It's like,
yeah,
so,
that's
and
poor form.
That year, no children received any Christmas presents because I had been terminated right before Christmas. But
that's just not even right.
But but again, there were so many of those situations, those situations that came up. Again, there wasn't that paper trail, and I was in a probationary period, which was the 90-day probationary period. So maybe you can address a little bit of that, because I think that when you're initially with an employer, and this was in New York State, they say, 90 days, if we think you're lousy, we're just going to get rid of you just because. And but yeah, eventually it led to some legal action. There was a settlement. I can't say what the settlement was because, in most settlements they say, well, we'll settle, but you can't really say what we've settled. And in many occasions they'll say, we won't admit any wrongdoing, but we might do something for you. So we'll put it at that. But I said, ultimately, I think it comes back to a lot of that could have been avoided. So what would have been your recommendation if, say, my employer had come to me and said, look, Santa Claus is not doing a great job here. He's in his probationary period. He's just not a good fit. We need to get him out of here. What would you tell him?
Well, first of all, I would hope never to be involved in the termination of Santa Claus, because that would probably impact my future Christmas presents. So putting that aside, if we're talking about perhaps a guy in a Santa suit, we'll make that the hypothetical. I guess my first question would be, as we talked about, does this employee know it's coming? Now, in a lot of places, you have a 90-day probationary period, and employers feel like, well, yeah, we can terminate someone during that 90-day probationary period without really giving a reason because they're on probation, which I guess theoretically is true. But in your case, you don't see this termination coming, and there were legal issues that caused you to go to, I guess, a federal agency, wasn't it?
It was a state. Yeah. I mean, I guess the blank that we have to fill in is that there were some labor violations that I had reported. So, and then, that could easily be looked at as retaliation. Now, in my opinion, I think there was some retaliation there, and whatever the case, but the way it was handled, I was able to, initially what I did is I went to the state because it was an employment issue, a wage and hour thing. But I could have just as easily applied or filed a complaint with the EEOC, because if it was a retaliation for a complaint about a labor violation, I believe that I could have gone to that agency as well.
Well, if you had made a complaint about a wage and hour issue, you could have gone to either the state agency, which you did, or the federal Department of Labor. And being a probationary employee does not mean that the employer can go ahead and terminate you anyway because you're a probationary employee. Once you make that kind of complaint, you are protected from retaliation. And then the way that the employee went about terminating you really it proves the retaliation more than anything else, because if there truly had been performance issues all along, and you had been written up all along, and you had been put through the progressive discipline process, then it would have been easier for the employer to say, well, we terminated Thom because of performance, and here's the trail of paper. Here's where we discussed the issues. Here's where we communicated the potential consequences. But doing it the way they did, where they just bring you in one day without notice and say, oh, by the way, you're doing a crappy job, goodbye, that makes it look like, well, maybe that's not the real reason they're letting Santa go. Maybe the real reason is they're a little upset that he complained about some wage and hour violations. And it sounds like you had enough of a case to perhaps get what we'll call a confidential settlement.
Yeah, and in all honesty, I mean, I the reason I took the confidential settlement was because I just didn't want to drag the process out. But certainly it could have been a situation where the employer, if it was somebody that was willing to dig their heels in and really make a huger issue out of it, it could have cost them a lot of money as opposed to a confidential amount of money, which may or may not have been substantial. So, yeah, and I agree. I think that if there was a paper trail that said, okay, you've done this wrong, this needs to improve, and even if it is during the probationary period, then obviously they would have said, oh, well, now you're saying it's retaliation, but yet you had all these other performance issues. They would have had a much better position to say that that's what it was, as opposed to, a bunch of things that were very minor. And even if you added them all up, I think a person with common sense would look at that and go, oh, this is why you terminated them? Well, that doesn't look great,
Right. Exactly. And probably the timing didn't help either. How soon after you complained did they terminate you?
Actually, it was within a week. Yeah.
Oh, yeah.
Yeah. It was within a week.
Yeah, that's nice.
So
yeah,
it was a
you
weird situation.
You had a good claim.
I did. And again, it was very sloppy. And I think even going back to some of the earlier things that we were discussing in terms of, PR and whatnot, I mean, to terminate an employee on the Friday before Christmas, that certainly would reverberate through the organization on some level. Because, I mean, I just think it's bad form. I mean, it's just, you just don't do something like that. And it was clear he was very, the term that my son uses often is butthurt. He was very butthurt at the complaint that I made. And I only made it, and we'll conclude on this, the only reason that I filed the complaint was because an employee came to me and threatened to sue me personally if we continued the practice within the agency. So I was literally caught between a rock and a hard place.
Or between a hurt butt and another employee.
Well,
who probably was butthurt too.
A lot of butts being hurt in that situation.
Yeah.
So.
And that's why we're always talking about covering your assets.
Covering your assets, because if your asset is covered, your butt won't be hurt. Maybe that's the maybe that's the overarching theme for the Cover Your Assets podcast.
Certainly for today, it is.
Certainly for today. Well, as always, it is a pleasure. I think this topic, again, is something that's very pertinent to a lot of people, and it's something we can revisit. And as you mentioned, you kind of teased that whole issue of sexual harassment and employee terminations and things like that. that may be a great topic as well. But how about some contact information for people to either send us topic ideas or further questions to follow up on this particular episode?
You can go to the blog, Cover Your Assets, on WordPress, or you can visit me on our firm's website. My email is kjj@wimlaw, WIMLAW.com. And Thom, let's put in a plug, because your buttery voice is not only on this podcast, but I understand you have a solo podcast. Why don't you tell our listeners about that?
Well, that is indeed called the Bagel Logic Podcast with, and my moniker there is Papa Thom. But yes, that's a kind of a companion podcast, and you will be a guest on that podcast at some point.
I hope so.
Talking about how wonderful it is to be my sister. Wow, if you could see the Zoom right now, folks, the look I just got from my sister. But she always tells me I'm her favorite brother, you know, and because I'm her only brother. You are my
favorite brother. Well, yeah.
All right. Well, until next week, everybody, thank you so much for taking the time to listen to Cover Your Assets. My name is Thom Jennings. That is my lovely sister, the attorney extraordinaire, Kathleen Jennings, and we will see you next week.